If you are currently living in the United States as an immigrant, if you are in the process of waiting for a visa to be approved, if you regularly send financial support back to family members in your home country, or if you depend on any form of government assistance such as Medicaid or food benefits, please stop whatever you are doing and give your full attention to what is about to be explained. A sweeping and transformative new law was signed on July 4, 2025, and its consequences are being felt right now throughout 2026. This is not based on rumor or speculation. This is enacted federal legislation. It is formally known as the One Big Beautiful Bill Act. It cleared the Senate by the narrowest possible margin, 51-50, with the Vice President casting the deciding vote. It passed the House by a margin of 218-214, and President Trump signed it into law on Independence Day 2025. After years of covering immigration policy in depth, this stands as the single most consequential piece of legislation affecting immigrants that has ever been covered on this platform. Its reach extends into filing fees, public benefit eligibility, tax obligations, family petition processing, the ability to send money internationally, access to healthcare coverage, children's eligibility for tax credits, and even the financial cost of challenging a deportation order. Over the next several minutes, a complete and thorough breakdown will be provided covering exactly what this law does, which populations it affects, what changes have already taken effect, what is still coming, and most critically, what actions you need to take immediately to safeguard yourself and your family. It is important to be completely transparent from the outset. Everything shared in this video is for educational and informational purposes only. It is not legal advice. Immigration policy is shifting at an unprecedented pace, and the details provided here are verified as of the current date. But circumstances can and do change. Always confirm the latest information through official sources including USCIS, the Department of State, and the IRS, and speak with a qualified immigration attorney about your individual situation. Now let us examine the full scope of what has happened. To truly grasp the magnitude of this legislation, it helps to understand the scale involved. The One Big Beautiful Bill Act, also identified as H.R. 1, was passed through the budget reconciliation process, a procedural mechanism that bypasses the standard requirement of 60 Senate votes and allows passage with a simple majority. The American Immigration Council, a widely respected nonpartisan research organization focused on immigration policy, released a thorough analysis confirming that this law allocates an additional $170.7 billion specifically toward immigration and border enforcement. To provide meaningful context for that figure, the entire operating budget for the Federal Bureau of Prisons during fiscal year 2025 was approximately $8.6 billion. This single piece of legislation directs roughly 20 times that amount toward immigration enforcement alone. The funding runs through fiscal year 2029 and is designated for border wall construction, expansion of detention facilities, recruitment of additional Border Patrol and ICE personnel, deportation operations, financial grants to states for immigration enforcement activities, and military presence along the border. The Brennan Center for Justice characterized the overall framework as creating what they called a Deportation Industrial Complex. That covers the enforcement dimension of the law, but the provisions that are actively landing in the mailboxes, bank accounts, and healthcare coverage of everyday immigrants right now are the dramatic fee increases, the benefit eligibility cuts, and the newly introduced taxes. Beginning with fees, because this is something that affects every single person currently navigating the immigration system, the One Big Beautiful Bill fundamentally restructured the cost of nearly every type of immigration application. For those pursuing a family-based green card from within the United States, the total USCIS fee now stands at $3,050, a figure confirmed directly on the official USCIS website. For applicants applying from abroad, the fee is $1,340. For individuals seeking asylum protection, a mandatory $100 filing fee has been introduced for the very first time in the history of the program. Beyond that initial charge, an additional $100 fee accumulates for every year the application remains unresolved, and critically, no fee waiver is available for either of these costs. The implications of this structure are serious. The immigration court system currently carries a backlog that stretches across multiple years. An asylum applicant who waits 5 years for a resolution, which is not an unusual timeline, would accumulate at least $500 in pending fees alone, entirely separate from the initial filing fee and work authorization fees. Regarding work authorization documents, the initial employment authorization fee for asylum applicants, parolees, and TPS holders has increased to $550, rising from $0 for asylum-based applicants and from $470 for others. Renewal applications cost $275, and the law limits authorization periods to a single year, meaning applicants must renew and pay again every 12 months without exception. The registration fee for temporary protected status jumped from $50 to $500, with no fee waiver option available. Filing an appeal of an immigration judge's decision now costs $900, up from $110. A motion to reopen a case carries the same $900 price tag, increased from a previous range of $110 to $145. And for anyone who received an in absentia removal order, meaning the immigration judge ordered deportation because the applicant failed to appear at a scheduled hearing, there is now an additional $5,000 penalty fee layered on top of all other applicable costs. The Catholic Legal Immigration Network, widely known as CLINIC, produced a comprehensive breakdown of these new fee structures and characterized the resulting system as pay-to-play, arguing that it effectively places legal pathways beyond the financial reach of thousands of individuals. An entirely new category of fee has also been created that applies to virtually every person entering the United States on any type of non-immigrant visa. Beginning October 1, 2025, every individual issued a non-immigrant visa, regardless of category, whether it is a student visa, a tourist visa, a work visa, or any other classification, must pay a mandatory visa integrity fee of $250. This was reported extensively by CNBC. The fee is designated as technically refundable, but only under highly specific conditions. After the visa has expired, the holder must demonstrate complete compliance with every condition of the visa and must not have made any attempt to extend their authorized stay. KPMG confirmed these details in a global mobility flash alert. A new $24 I-94 application fee has also been introduced. These costs accumulate rapidly, particularly for families and for applicants from countries where these dollar amounts represent months of earnings. USCIS subsequently announced that many of these fees received an additional inflation-based adjustment effective January 1, 2026, on top of the base amounts already established. Then effective March 1, 2026, premium processing fees were increased yet again. The fees are not simply elevated, they are continuing to rise. Every viewer is strongly encouraged to visit the USCIS website directly, specifically the alerts section, to obtain the most current fee schedule, because the amounts described here may have already been adjusted upward by the time this is viewed. Turning now to the provisions that are already causing devastating consequences for immigrant families across the country, specifically the changes to public benefit eligibility. Prior to this law, immigrants holding certain lawful statuses, including refugees, asylees, TPS holders, trafficking survivors, and VAWA self-petitioners, had access to programs including Medicaid, the Children's Health Insurance Program, known as CHIP, SNAP food assistance, and in certain circumstances, Medicare and Affordable Care Act premium tax credits. The One Big Beautiful Bill has stripped most of those categories of eligibility. The National Immigration Law Center, known as NILC, published a comprehensive analytical report confirming that under this legislation, only 3 categories of non-citizens retain eligibility for Medicaid, CHIP, SNAP, Medicare, and ACA premium tax credits. Those 3 categories are lawful permanent residents holding green cards, certain Cuban and Haitian nationals classified as entrants under existing law, and individuals from Palau, Micronesia, and the Marshall Islands under the Compact of Free Association. Everyone outside those 3 narrow categories, including refugees, asylees, TPS holders, trafficking survivors with T visas, and domestic violence survivors with VAWA protections, has been or will be removed from eligibility. The timeline varies because different programs are being phased out at different points. Changes to SNAP eligibility took effect immediately upon the law's enactment in July 2025. The USDA Food and Nutrition Service has already released implementation guidance. If you were receiving SNAP benefits and you do not fall into one of the 3 eligible categories, your benefits may have already been terminated, or a termination notice may arrive shortly. Changes to Medicaid and CHIP eligibility take effect on October 1, 2026, which is now less than 6 months away. NILC has confirmed that beginning on that date, refugees, asylees, TPS holders, and many other lawfully present immigrants will lose their Medicaid coverage. Changes affecting Medicare took effect immediately when the law was signed, but individuals who were already enrolled as of July 4, 2025, received an 18-month grace period, meaning their coverage may continue until approximately January 2027. NPR published a deeply reported story in April 2026 about a 67-year-old woman with TPS status who spent years contributing to Medicare through her payroll taxes. Under this law, her coverage will be discontinued because TPS holders no longer qualify for the program. The NPR report estimated that approximately 100,000 lawfully present immigrants could be removed from Medicare coverage as a result of this change. The law also introduced new tax obligations that affect millions of people. A 1% excise tax now applies to remittance transfers, defined as money sent from within the United States to a recipient located in a foreign country. This tax took effect January 1, 2026. The IRS has confirmed this on its official website and has issued proposed regulatory guidance. If you send money to family members in another country through any remittance transfer service, 1% of the total transfer amount is now subject to taxation. The exemption applies only when the transfer is funded by a United States citizen drawing from their own bank account. This means that if you are a green card holder, a visa holder, or any non-citizen, you are almost certainly paying this tax on every dollar you send internationally. 1% may appear modest, but for someone sending $500 or $1,000 monthly to support extended family overseas, the cumulative annual cost is meaningful. The original House version of the bill proposed a 5% rate, which was negotiated down to 1% during Senate deliberations. But as RSM, one of the largest audit and tax advisory firms operating in the United States, noted in their published tax alert, this represents an entirely new category of excise taxation with no precedent in American tax law, and it is directed specifically at non-citizens. The law further restricts eligibility for several significant tax benefits. The enhanced senior deduction of $6,000 available to taxpayers aged 65 and older is now restricted exclusively to individuals whose Social Security number is valid for employment purposes. Taxpayers who file using an individual taxpayer identification number known as an ITIN are ineligible to claim this deduction. The same restriction applies to new deductions created for tip income and overtime income, as well as to the American Opportunity and Lifetime Learning Education tax credits and the child tax credit. NILC estimates that approximately 2.6 million children living in the United States will lose access to the child tax credit because no parent listed on their tax return holds a qualifying Social Security number despite these families paying taxes regularly. The situation surrounding the 75-country immigrant visa pause must also be addressed because it is directly aligned with the same policy direction driving everything else. On January 14, 2026, the State Department announced an indefinite suspension of immigrant visa issuance for nationals of 75 countries, citing public charge concerns. This measure operates independently from Presidential Proclamation 10998, the travel ban affecting 39 countries that took effect January 1, 2026 on national security grounds. Both restrictions are currently active simultaneously. The 75-country list encompasses nations across Africa, Asia, the Caribbean, Eastern Europe, and Latin America, stretching alphabetically from Afghanistan and Albania through Uruguay, Uzbekistan, and Yemen. The State Department's own official website confirms that interviews continue to be scheduled and conducted at embassies and consulates worldwide, but the actual issuance of immigrant visas remains suspended. A major legal challenge filed February 2, 2026 in the Southern District of New York argues that this pause constitutes an unlawful nationality-based ban on legal immigration. As of this date, the case remains active in litigation, but no broad injunction has been issued. The Visa Bond Program has also expanded, now covering 50 countries as of April 2, 2026. Reuters reported that 12 additional countries were added in March 2026, and nationals of those 50 countries who apply for B1 business or B2 tourist visas may now be required to post a bond of up to $15,000 as a condition of receiving their visa. The stated justification is reducing visa overstay rates, but for countless applicants, the financial barrier this creates is insurmountable. Expanded social media screening also took effect March 30, 2026. The State Department confirmed that online presence reviews now apply to additional non-immigrant visa categories beyond those previously subject to screening, including K-1 fiancé visas, R-1 religious worker visas, T visas for trafficking victims, and U visas for crime victims. Temporary protected status also faces a critical moment. The Supreme Court is scheduled to hear oral arguments in cases involving TPS designations for Haiti and Syria. Analysis from legal observers indicates this case could have implications for the future of TPS across all 17 currently designated countries, potentially affecting 1.3 million people. If you hold TPS status, this is a moment that demands close attention and, if at all possible, active legal counsel. The DHS biometric entry and exit program expanded through a final rule that took effect December 26, 2025. CBP is now authorized to collect facial biometric data from non-citizens at airports, land ports, seaports, and other authorized entry and departure points. Coverage of this program's quiet expansion across American airports has raised significant privacy concerns among civil liberties organizations. Stepping back to consider who is directly affected by all of these changes, the honest answer is virtually everyone currently involved in the immigration system. If you are applying for any immigration benefit, your fees have risen substantially. If you are a refugee, asylee, TPS holder, or parolee, your access to Medicaid, SNAP, and related programs is being eliminated or is scheduled to be eliminated within months. If you send money to family living abroad, you are now subject to a 1% remittance tax. If you file taxes using an ITIN, you have lost eligibility for several important deductions and credits. If you are a national of one of the 75 affected countries, your immigrant visa processing is frozen indefinitely. If you are applying for a visitor visa from one of the 50 countries in the bond program, you may be required to post a $15,000 financial bond. If you hold TPS, the Supreme Court is on the verge of issuing a decision that will determine the future of your status. And if you enter the country on any non-immigrant visa, you are now subject to the new $250 visa integrity fee. Here is what needs to happen immediately. First, review your immigration status carefully and determine exactly which provisions of this law apply to your specific situation. USCIS has a dedicated section on their website for HR1 fee updates, and NILC has published some of the most thorough analytical resources available. Second, if you currently receive Medicaid, CHIP, or SNAP benefits and you are not a green card holder, contact your state benefits office without delay to understand your current eligibility status, because changes are either already active or will become effective on October 1st, 2026. Third, if you send money internationally, speak with your remittance provider about how the 1% excise tax is being applied and incorporate that cost into your financial planning. Fourth, if you are preparing to file taxes, ensure that your tax preparer fully understands the new ITN restrictions affecting the senior deduction, the tip and overtime income deductions, and the child tax credit. Fifth, if you have any pending immigration case, review the updated fee schedule with your attorney, because costs have changed significantly and fee waivers have been eliminated for many categories. Sixth, if you have TPS, follow Supreme Court developments closely and develop a contingency plan in preparation for the outcome. Seventh, do not rely on social media or informal word of mouth for immigration information during this period. The pace of change is too rapid and misinformation is too widespread. Go directly to uscis.gov, travel.state.gov, and the IRS newsroom for authoritative guidance. To everyone watching who feels overwhelmed or frightened by the sheer volume of these changes arriving from every direction simultaneously, that reaction is completely understandable. These are enormous shifts affecting fundamental aspects of people's lives, but it is equally important to recognize that legal challenges are being actively pursued in courts across the country. Advocacy organizations are working without pause. Immigration attorneys are standing ready to assist with exactly these situations, and a community dedicated to staying informed and prepared continues to grow. Knowledge is your most powerful protection right now. The deeper your understanding of what is happening, the more effectively you can plan your response, the better you can shield your family from negative consequences, and the more confidently you can pursue every legal option available to you. Everything shared in this video draws on official government sources, including USCIS, the Department of State, the IRS, the Department of Homeland Security, and Customs and Border Protection, as well as verified reporting from credible outlets and established immigration policy organizations. Immigration law is complex, and it is evolving with extraordinary speed. This video is educational content, not legal advice. Every individual situation is unique, and decisions about your specific case should always be made in consultation with a qualified immigration attorney. If this video helped you understand what is happening, please share it with someone you care about. Share it in family messaging groups, at houses of worship, at community centers, anywhere that people who need this information gather. Every person who understands their rights is a person better equipped to protect themselves. Check the description below for official resources and additional information. Take care of yourself. Take care of your family. Know your rights.